Good morning, everyone. It's August 26th, and we're going to go ahead and begin our next session of our California Law Revision Commission meeting. First item on the agenda is number 1, the minutes.
I move to adopt the minutes.
Second.
Very good.
Could I, for reasons that I'm going to explain, and let me first say we don't have any proposed revisions. For reasons I'll be explaining shortly, I'm going to try calling the roll when we have formal decisions that we're making. And so I'm going to start with this one, if you'll indulge me. Carrillo,
Aye.
Cubas.
She's on mute.
She's muted. Yeah, we'll come back.
Anna, you're muted.
We'll come back to her. I think she's on the phone.
Oh, okay.
King,
Yes.
Miller O'Brien,
Aye.
McAllister,
Aye.
Rubin.
Aye.
Simpson. Aye. Commissioner Cubas, how do you vote
Present.
on the
Thank
minutes? We're
Yes.
voting minutes? Yes,
Vote
okay.
Yes, thank you.
You missed it. I explained that I'm doing roll call votes today, and I'll explain why in a few moments.
Got it. Thank you.
So that completes that.
Okay, so we'll move on to the second item on the agenda, which is administrative matters, and we'll have the report of the executive director. Brian.
Okay, so good news, bad news. The good news is we have hired a new administrative person, a gentleman named Adam Brover, who's going to be starting in early September. So I'll introduce you at the next meeting. That is going to coincide with a limited reopening of our office. We're going to give it a try. And initially, I think it's just going to be that Deborah Larrabee or I will be in the office with Adam to supervise his first weeks of work for us. It's going to be nice to have another set of hands. We always have a long list of to-do items administratively that just sort of gets kicked down the road because of higher priority stuff.
Brian, he's replacing Vicky.
Oh, yeah, effectively, yeah. Yeah, Vicky was a secretary, and she actually has been doing some work for us as a retired annuitant, doing some of the things she's great at. She's an excellent technical proofreader. So, but yeah, he'll be full-time and working in the office in Davis. I guess the bad news, it's not terrible, is that our number came up on getting audited. There are a couple of we're actually being audited by 2 different entities right now. The Department of General Services is auditing our procurement practices, and the State Personnel Board is auditing our personnel practices. And neither one of those was triggered by any kind of allegation of misconduct or anything. There's just every agency gets audited, and we came around in the rotation. It's bad that they're both happening at the same time because it's pretty work intensive. We have to be available to provide them with records whenever they want them. And we're digging through our last year's procurement and personnel records to provide them to the auditors. And that's keeping Deborah pretty busy.
It's probably nice for you to have Vicky, though, a little bit, to kind of maybe if she recalls anything. So that's good.
Yeah. And last thing, at a prior meeting, Commissioner King asked that we periodically provide updates on the work of the Committee on Revision of the Penal Code.
Yeah.
So one thing is that we are on the cusp of doing a recruitment for another attorney for them. In this year's budget, the governor authorized and funded 2 more attorneys for the committee. And we have spent the last month or 2 trying to herd the cats at DGS to get that listing to go live. And I'm told that we are looking at the last hurdle and it should happen soon. So that's also going to be occupying some time. When we recruited for the office technician, the position we gave Adam, there were over 100 applicants for an entry-level office assistant job. So I don't know what the work environment and job market is like, but we may see the same thing with attorneys, and it's just very proceduralized, time-intensive stuff doing state hiring.
But it also speaks to the state of the economy. That's bad.
Yeah. The Committee on Revision of the Penal Code is on the cusp of approving a report on the death penalty. And that is going to be put into print for public distribution soon. I don't know that I have permission to say exactly what's in it. I can update you later. And as soon as that report is publicly released, I'll make sure that I send a link to each of you in case you're curious to see what they're doing there. There are still 6 bills pending that were based on their recommendations that are still viable. Running the gamut of a lot of it technical sentencing related stuff, like changing the mandatory minimum rules for some crimes, or adjusting when courts can dismiss sentence enhancements, modifying the rules on good conduct credits for people who are confined in institutions other than jails and prisons, but are still doing sentences, so that there's equity across all incarcerated people, those kinds of things. And we will see at the end of this year or next what success they have. And that's all I have for the executive director's report.
Very good. The next item would be commissioner suggestions. Do you guys have any suggestions that you want to bring forward at this time? No one? All right. The next item is use of teleconferencing.
Yeah, at this point, this is mostly an informational memo, because we're sort of at the mercy of the law and whatever it turns out to be. We've talked about this before, and I wanted to give you an update. One of the most significant facts is that the governor had issued an executive order that extended the waivers for use of teleconferencing through, I believe, the end of September. So we can do it permissibly here. We can do it permissibly in September. After that, we're going to have to wait to see whether that those waivers are extended by executive order or whether there's a statutory change. I looked to see whether there were statutory changes on the horizon. There, as far as I could tell, there's currently no legislation pending that would make the necessary adjustments to the Open Meeting Act. As I explained in the memo, there is trailer bill language that the governor approved and posted to the Department of Finance's website that would adjust the open meeting laws. That trailer bill language, as far as I can tell, has not yet been introduced into a vehicle. So that it's not live actual legislation yet, as far as I can tell. And if it were introduced and approved, because it's a budget bill, it would take immediate effect on signing. And as I explained in the memo, that bill would actually require that public meetings be conducted by teleconferencing. And as far as I can tell from the language, it wouldn't preclude an in-person component for those meetings, but the teleconference component would be mandatory. So if that were introduced and enacted, we'd be looking at a new situation where not only would we be permitted to use teleconferencing, we'd be required to use teleconferencing at all meetings. And the thing that would be permissive would be including an in-person component. So as I mentioned, I think at the last meeting, I've been doing some thinking about how we could do a hybrid meeting, and bought some equipment. And that's one of the things I'm going to be doing with the new office technician in a week or two, is setting some of that stuff up and doing some experimentation to see how practical it is. But as I said, that's not a bill yet. It's just draft language sitting on a website. So I'm going to continue to keep an eye on it, and we'll update you again in September. And hopefully, I can't imagine that we're going to return to the old system where Commissioner McAllister just let me know that she dropped but is reconnecting. The old system where in order to do teleconferencing that involves a member of the commission, you would have to hold the remote location open to the public. So each of your homes, you'd have to have noticed them as publicly open meeting locations if you were going to participate by teleconference.
My pit bull will welcome anyone.
That's good.
She's very nice.
So anyway, that's the situation. We're still waiting to see what the legal environment is come October, because we're good through the end of September. After that, I don't know. I did provide a supplement to that memo where I pointed out that the Little Hoover Commission had released a report endorsing some kind of a change to facilitate and encourage remote meetings. And they did a poll. I participated in it. They did a poll of agencies to ask, what has been your experience? And I reported to them, as many agencies did, that, teleconference meetings seem to work well and definitely encourage public participation. We don't see it so much on the commission side, I don't think. Sometimes we've had meetings where there are a bunch of people attending, but usually it's sort of the same group of people that we'd see if we were in the Capitol. But the Committee on Revision of the Penal Code, when they were in the Capitol, there was, for their inaugural meeting, which was kind of a big deal, Governor Newsom was there and spoke. That was probably 25 people in the audience physically. Every meeting they've had since then has had over 100 people. And public comment usually runs to like 10 to 20 people who want to make prepared remarks to the committee. So, and then that just, I'm pretty confident that would not be possible if we were in a hearing room in the Capitol. So anyway, that's the situation. No change yet, but we're monitoring it. Any questions about that?
Brian?
Yeah.
The governor could extend that by executive order, assuming he's still governor, right?
Yeah, I believe so. Assuming that the declared state of emergency continues.
Okay.
Okay, that's all I have on that item.
Okay. We'll move on. It's the election of officers. Brian, did you want to lay out just the?
This is memo 2134. We need to elect a chair and vice chair for next year, beginning on September 1. The terms of office end on August 31st. So whoever we elect would, as chair, would be chair for our September meeting, but our current chair would continue through the end of this meeting. I see a hand up from David.
I nominate current Vice Chair Richard Simpson for chair.
I'll second
Jane?
that. I'll second that.
Oh, okay. So I forgot. I promised you I was going to talk about roll call voting, and I forgot. And I was going to do it in connection with that open meeting teleconference.
I raised my hand.
Yeah, that's good. I'll write that down.
We just had to do roll call, and then, but Jane had her hand up. Did you want to? Okay.
Yeah, actually, I thought maybe she did. So what I was going to explain is one of the components of the existing Bagley-Keene Act that governs teleconferencing that was not waived by the executive order was a requirement that teleconference meetings use roll call voting. And, I have been lax about that because, when I can see everyone and I can see that everyone's nodding and assenting, it feels kind of superfluous to call names and record votes. But bearing down on these issues and looking closely at the open meeting requirements and to the extent that I've been doing lately, it has become uncomfortable for me to continue to sort of circumvent what seems like a black letter requirement that is unambiguous. And so as much of a nuisance as it will be, and maybe not really that valuable, I feel obliged to at least propose that we conduct a formal roll call for every sort of decision of final importance. We'll have to sort of fudge our way through what what might just be an understanding like, okay, so the staff will look at this issue and bring you back something on that. The question you asked, yeah, that's right. That might not make it into a roll call vote, but approving the minutes, electing officers, approving a final report, things like that, I would feel more comfortable if we did a formal roll call. Anyone have concerns about that?
I do have a question. Are we recording these outside of because I know we're recording them visually. Are we also recording them with an audio tape like how we normally or we used to do in person?
I think Zoom does that by default.
Yeah.
I don't think there's an option to record only video.
She's
Well,
asking if we also run.
The question
audio,
is like, what is our
audio.
record?
Yeah, this is our record. The part of the problem is that we're also required when we record votes in the minutes to record ayes, noes, abstention, not present. And there are sometimes when a commissioner's screen goes dark for a moment because they're like turn their video off because they're going to step away and do something and then come back. And it isn't always clear to us, like, are they present? Are they there? Did they also assent? And then the other thing is, I'm not 100% sure who controls what gets recorded in terms of a gallery view versus say speaker view. And I think that at least for our practice, I've never dug in and figured out how to change it if I wanted to. Our default is that our recordings show the speaker. So if I say, does everyone agree? And everyone puts their thumbs up, but if somebody coughs, the person who coughed is going to be shown with their thumb up and nobody else will. And so I know it, but I don't have a proof in the record. So is it all right if we go to that as annoying as I think it's going to be?
Yeah, no,
Commissioner Simpson?
Yeah, just a question. What to kind of streamline it, potentially streamline a little bit. I know in the legislature, they have a practice of saying, like if there was a unanimous vote, they would say on the next item, is there objection to using the previous unanimous roll call? Hearing none, ayes 7, noes none, or ayes. So is that?
Yeah, well, and there's even a shorter version of that. In the fiscal committees, they do what's called a roll call A and B.
Roll call A, B, and right.
And roll call A means all the majority members, or roll call A means everybody.
Everybody.
Unanimous. Roll call B means party line.
Right.
I
don't know if that was, it's an option.
Barbara?
I think that might not work with the problem that we have is that, people disappear temporarily from the screen. And if they're not listening, then when you say, roll call such and such, is it okay to use that? They won't hear and they won't speak up.
Okay. I mean, there's only 7 of us, so.
Yeah.
Yeah, I think the roll call way is probably best. And only because, Brian, I agree. I'm not sure if the recording is capturing the gallery view or the speaker view.
Yeah.
Brian, you should have control over what the audience sees, which is what gets recorded. So like we can individually, like right now I have you guys on gallery.
Yeah.
But you, Brian, as the host, you can change what everybody sees, and that's what gets recorded.
Okay, maybe I'll look into that. I actually think that as nice as it is to see a larger image of somebody who's speaking and be able to like get a full impact of their emoting, I kind of think the gallery view might be better as a record.
Yeah. Especially because we have been making references to, I think we've honestly done a pretty decent job of saying, okay, I see everyone assenting, or it looks like so-and-so's left the room. Did you want to abstain? I do think because we are cognizant of that. Yeah. So I don't think we've been slipping too much, but I do think if you look into how the recordings are actually captured, and then maybe next meeting we would come back and vote, that probably might make sense instead of making roll call be required of all necessary votes.
Commissioner McAllister?
I just don't think it's that big a deal to call roll call for us. There's so few of us, and gallery view is perfect because we can all see each other at least, and we can have some form of recognition of how things are transpiring. I feel like it's not a big issue. We really shouldn't waste a lot of time worrying about it or researching it. Let's just vote, be done, have ourselves of record and move on. And then there's no equivocation about whether it's okay or not okay, or someone's not in the room. Let's just do it.
It's certainly easiest. Yeah. So I saw a motion and a second on Richard Simpson for chair next year. I'm going to call the roll. Carrillo.
Aye.
Cubas.
Yes.
King.
Aye.
Miller O'Brien.
Aye.
McAllister.
Aye.
Rubin.
Aye.
Simpson.
In my defense, aye. Thank you all. I appreciate your confidence, your support. I do want to say that I also appreciate my two predecessors, Crystal and Victor, for the being good models to follow, setting a high standards for leadership, particularly Crystal, having guided us through this challenging time with wisdom and grace. So thank you all.
Thank you.
And now we need a vice chair. Nominations?
Sure. I'll nominate Commissioner Carrillo.
One good term deserves another.
We haven't talked.
Even though he doesn't have his Star Wars backfield, I'll
Yeah.
second that.
I know, I feel like I'm letting you down. I will resolve to do better in that area in the future.
Any other nominations? Okay, I'm going to call the roll on this as well. Carrillo?
Don't jump at once, you.
Hey, alphabetical, always. Cubas?
Yes.
King?
Yes.
Miller O'Brien?
Aye.
McAllister? Oops, that's not alphabetical. Rubin?
Aye.
Simpson?
Hi.
Okay. Thank you. That completes that item.
And I do disagree. Normally we hand over the gavel and we say here. So you have to be ready to go. That is the normal. Okay, I've been on the commission now for 10 years. That's the deal. But anyway, and then this is my last term, you guys, or I have one more meeting and that's it.
Wow.
Oh, you end at the end of this year?
Oh, October, yeah.
Well, then can we have a round of applause for our esteemed leader, Crystal O'Brien?
Thanks, you guys.
So you didn't apply for reappointment?
And, no.
Okay.
No. I was gonna ask you, did you do that? I didn't do it. No.
I'm on a slightly different term. I think I have a couple of years left.
Yeah, no.
Well, I guess it would surprise me if you were the only one whose term is coming up. So I'm gonna have to double check on that and get back to people whose terms end short.
I think Rick, Anna, and I all started at the same time. So, and it's 4-year terms, right? So it's not us.
No, the terms are different.
Oh,
They're 4-year terms, but they're staggered in 2-year classes. And so sometimes people, if there's a vacancy that's being filled, even though they're being appointed new, they might get appointed to a term that only has 2 years.
well, that actually could be important information for me then, because I've been on for 2 years and I could be termed out.
Yeah, I apologize for not having thought to check that, and I will check it and get back to people later today.
The previous governor used to, their appointment secretary would call you to give you the heads up on what they're doing.
Okay, so that concludes that item, and we're on to the legislative program. Memorandum 2135 and a supplement. And the main memo just reports that everything is mostly moving along fine. It does not report on the Public Records Act bills because that's the subject of Barbara's supplement. But of the other bills, one has been signed by the governor and chaptered. That's AB 414 Mainshine. That's on trial court restructuring. So that's been passed. 1578 is the Assembly Judiciary Committee bill that includes our provisions on eminent domain. And that, I believe, has been approved by the Senate and is on its way to the governor. ACR 24 Chow That's our resolution of authority. That's on the Senate floor on the consent calendar. So I'm expecting approval soon. And SB 391 min, which is the bill on CID meeting procedures, that has been sent to the governor. And SB 315 is the same status that was reported in the memo. It's on the floor. So everything looks good. And as I said, the supplement addresses the two bills on Public Records Act recodification, and I'm going to let Barbara talk about that.
Okay, well, these two bills are doing fine. They're pending on the third reading file in the Senate now. And everything looks good. There were some, recent amendments that are very technical, just trying to basically implement the commission's intent, correcting mistakes and things like that, coordinating bills. Because of the recent amendments described in the supplement are some revisions to the comments, because the Office of Legislative Counsel backed out a few changes in one of the bills. And the question for the commission at this point is whether the comment revisions that are described in the supplement are acceptable to the commission. And again, I think we need a roll call vote. So Commissioner Creel?
Aye.
Kubas?
Yes.
King?
Yes.
McAllister?
She got disconnected and is in the process of trying to reconnect, but I don't
Okay,
see
we'll
her
come
yet.
back to her. Miller O'Brien?
Aye. And then it looks like we have a guest also too.
That's our student employee who's going to be joining us
Oh,
for the
that's
next
right.
item.
Okay.
Rubin?
Aye.
Simpson?
Aye.
And McAllister?
I'm sorry, guys. I had to step away for 1 second. I had an emergency thing come up. Can you refresh me on what we're voting on?
We're voting on the revisions to the comments to one of the CPRA bills
Oh.
that are described in the supplement on the legislative program memo.
Right.
Are
Aye.
those acceptable? Okay.
Thank you.
All right. Well, that's all there is on that memo.
Okay, then with that, we're going to move on to the item number 4, which is the emergency related reforms.
And that is why we now have a window in the gallery view for Alexandra Azad, who's our King Hall student who did the work on this topic and is going to be presenting it. Good morning, Alex.
Good morning.
Okay, so as the director said, my name is Alex Azad. I'm a third-year law student at UC Davis School of Law. I spent my summer working on this report on COVID-19 legislation. I was able to do this research because of a 2020 request by the commission to be granted the authority to study emergency reforms. That resolution is currently pending, so this report is to sort of lay the groundwork for further study on emergency legislation as a sort of comprehensive review of what happened during the COVID-19 pandemic. My report focused on COVID-related legislation in California that was proposed and enacted in 2020 and enacted legislation in 2021, as well as COVID-related legislation that was proposed and enacted in 2020 and 2021 in the states of Massachusetts, Minnesota, New Jersey, and New York. My search was more limited in California as I didn't cover like proposed only enacted legislation in 2021. And I limited my search in all of the states I researched to the more relevant bills. And this assessment of relevance was a joint decision by myself and the executive director. I conducted this research primarily using the National Conference on State Legislatures database on state action on coronavirus. This database was incredibly useful to me, and it allowed me to search for state COVID action based on the state, as well as the topic and the year. And so I used this database to categorize my findings into the topics and subtopics, which are covered in the report. As explained in the memorandum, most of the non-California laws that I found were things that were already handled by the California legislature or addressed in other similar ways, or they were topics that would be best handled by those who are experts in whatever that particular field is, whether it be the Department of Health or Emergency Services or another regulatory agency with jurisdiction. As the executive director indicated in that memorandum, it would be probably premature to make any decisions based off of this report, which is purely informational in nature. At this point, this report is essentially just a resource that the commission can use when the commission considers its next topics and priorities memorandum. That being said, this research gave me a really interesting look at what California and the other states I mentioned have done. The states covered all extremely important topics, many of these really vital issues related to targeting, the secondary effects of stopping the spread of COVID, so things involving the interruption of education, work, government operations, medicine, and economic losses that impacted housing. Other topics dealt with COVID more directly through the protection of vulnerable populations, ensuring adequate PPE supply, vaccines, mask mandates, and emergency workforce preparedness and support. Finally, some topics, particularly those focused on executive authority during the pandemic, were political in nature and raised questions about how far executive power could reach during an extended emergency such as the pandemic. As you can see from the report, I covered a lot of statutes, so I may not be able to answer any specific questions you have about specific statutes. But if any of the commissioners have any questions for me, I'm happy to talk more about my research.
Richard or Mr. Rubin, Commissioner Rubin.
My comment is very short, which is to say that I want to personally compliment you, Mrs. Odd, for the work you did on this. It's extremely thorough. Obviously, it was a considerable effort on your part, taking away from your usual studies, which are onerous to begin with. So I hope I'm speaking on behalf of the entire commission, which I don't have to do, but I'm sure they'll agree that you did a really superb job on this, and I compliment you and admire you for what you did.
Thank you. That's very nice. I appreciate it.
It was really helpful. This is the kind of work that I think we had to do as to lay the foundation for considering if we get this authority to deal with emergency related law, are there issues out there in other jurisdictions that we would have to take into account either by sort of emulating or steering clear of or anything like that. I think as it turned out, there's not a lot of that kind of thing revealed in the work. The contours of what the other states did is very similar to what California did, and not particularly surprising. We didn't come across anything that that was startling or revelatory. But we had to take the look to make sure that that was the case. And it was really helpful at a time when we're stretched really thin to have Alex be able to do that so comprehensively and carefully.
And as an employment lawyer, I can tell you that you did a really, really good job, and that this stuff kept, I know most of people in my area so busy. And you did a really good job. It's a great way to start. And there are even Lexis and Westlaw, they don't really have, they might have charts, and even that's what, like I did at my firm, we just created charts. This is very nice. It's comprehensive. You did a great job. If you want to do employment law, this is it's a good writing sample.
Thank you.
And, as I said in the memo, in the part that I wrote, I think that in particular, the commission should defer decision on these things until we do the new topics memo. And that's partly because we don't yet have the authority that ACR 24 is going to confer. I expect it, but you never know. And then there's another thing, which I guess I should have mentioned in connection with the legislative program, and it slipped my mind, and apologies, which is that there is a resolution out there, ACR 95, that would assign the commission a new study. And I don't know that it'll pass this year, but it might continue and be a 2-year enactment. That would be a huge new topic. The proposal is that we study antitrust law and modernizing California's antitrust statute. And if that gets assigned to us, then I think that's going to be sort of an all hands on deck topic for the staff, and that could seriously limit the time we have to do other topics, including this one, emergency related reform. So I think it's helpful to have sort of loaded into our heads the range of potential issues that are out there, but I would suggest that we postpone making any decisions until we have a better sense of what our resource picture is going to be for next year.
Yeah, the antitrust bill, it's actually exciting. The timing is good too, for who knows what's going to happen in 2022. So that's good.
I do have a question though, for Commissioner Carrillo in particular. Yesterday, in preparation for the meeting, I was rereading the California case Newsom versus Superior Court, which was California's attempt legislatively to curtail the governor's emergency powers. And one of the things that I had sort of thought of as a possible topic in this area would be to look at the Emergency Services Act and see if there was any way to sort of flesh it out with powers that we have learned are particularly important during emergencies that might not have been expressly included. I don't think they have to be expressly included because the act grants the governor all of the state's police powers. But I thought it might be helpful to like memorialize some of the powers that are the most controversial or could be important particularly in an infectious disease emergency. And I also was wondering a couple months ago whether there would be any need to sort of bolster the act to fortify it against claims that it's an unconstitutional delegation. And in rereading the opinion in Newsom versus Superior Court, I noticed that our illustrious colleague David Carrillo is an amicus in that case. And so I was just curious, David, whether you see any utility in the commission looking at those kinds of tune-ups to the Emergency Services Act if we get this authority to deal with emergency powers.
I do. I think that would be very useful and important. I think when we talked about this a couple of meetings back, I generally spoke in favor of it. And it was partly from the experience that I had of working, as an amicus in that case. I think where we are now is that courts have pretty uniformly rejected all of the challenges that have been made in this context and in past ESA contexts. So if we didn't do anything, I think we'd be okay. Yeah. But that obviously depends on, that leaves open lots of questions about how future courts deal with future emergencies, based on emergency orders issued by future governors. So there are a lot of uncertainties there. So, the way the law is, we'd probably be okay, but, like we're all lawyers here, so we're about eliminating uncertainty. So if there is an opportunity to do some cleanup, I think that would be well worth our effort.
Okay, well, I will include that possibility when we come back for new topics. The other thing that sort of caught my eye in when I was reading Alex's findings as something that might be useful to address, but may be difficult politically, is the bills in states that allowed sort of temporary licensure reciprocity for licensed professionals from other states to come in and provide emergency assistance. So like I know, Commissioner King, you've served on the nursing board. It's conceivable that in an emergency, California would need an influx of nurses to help deal with a disease emergency. And I'm not sure what kind of licensure obstacles there might be to those people coming in and practicing in California, not permanently, but for the duration of the emergency. And it occurred to me that there might be some usefulness to looking at that issue broadly and seeing whether there would be some kind of broad emergency reciprocity rule that we could enact for any number of professions. The reason I'm not sure about that is because I imagine that there would be concern about people who were licensed under lower standards, maybe not meeting the standards of care that California would require, or being aware of our standards. And then the other thing is just sort of the professions looking askance at the idea of a whole influx of other people coming in and taking jobs that might otherwise be held by Californians.
Brian, in the nursing field, don't forget a lot of nurses come from outside the country too. So I don't know if that's an important issue for what you're talking about, but it's not just from other states. A lot of nurses are trained outside of the U.S. and then have to do additional things before they get approved in California.
Yeah, and then you have the California, the regulatory boards, you have additional regulatory agencies that also might manage prescriptions and physician's assistants, people who are kind of considered paraprofessionals. I would think that the emergency assistance would lend itself only to actual services rather than like writing prescriptions or performing services that require specialized training, like maybe attending children that look abused, different things. And I only say because I do employment with doctors, medical facilities. So
well,
yeah.
I did notice, I think it was in California, a measure that authorized pharmacists to administer vaccinations. You know, and that could be something like if you are on the border, you know, in Yuba, or well, I'm going to display my ignorance of California geography. Sorry, I'll stop. Let's say Tahoe, and you need to bring in some pharmacists from Reno to staff a vaccination program. What kinds of licensure obstacles are there to that happening, and what kind of delays would it introduce? You know, and I don't know all the answers to that. It's just something since
I did a survey, kind of like what Alex did, of all the pharmacies for most states. And that is because every state has different standards, and you know, in terms of regulating COVID testing and what could happen with those tests. So and then not only, Brian, then it's not only the states, then it's the counties, and it could be the cities, and it could be the unincorporated. It's right now what we just experienced was so ridiculous. But there were like 5 or 6 attorneys, and that's all we did for like a week, managing like, you know, 14, 15-hour days trying to research this stuff. And I'm sure we didn't even get it all covered. It's very, very complex.
So that's just an idea that I had as something that could be on the short list. Like I said at the outset, and Alex said in her presentation, you know, a lot of the reforms that we saw in other states were just unsurprising responses to this particular emergency. You know, requiring social distancing or masking or vaccination, or providing assistance to medical professionals and the equipment that they need. And, you know, those are the kinds of responses that are particular to a specific kind of emergency that would be kind of hard to anticipate and address in a more general way, in a more sort of laying the groundwork for quick response. That I think would be the most useful thing for us to look at, is like tailoring sort of the legal landscape so that emergency responses don't run into obstacles. And so we just didn't see a whole bunch of that in the findings of Alex's research.
I mean, we could do it though, because I do think that a lot of states look to us. There are some states that didn't have anything together, and they just looked to us or deferred to us and adopted whatever we had. And then because we have film studio employees that travel from place to place, then that is also why some other states will look to us. Like Missouri didn't have any kind of schemes. So then they might look to what LA is doing, or the city of Santa Monica, or West Hollywood. So it actually, believe it or not, that could actually be worth it for future projects, even Brian, for the commission and other students to look into this, because what just happened was a disaster.
So does anyone have any questions about any of this before we close the discussion? So my intention is that we'll just bring this back in connection with new topics and maybe flag the two issues that I mentioned, but commissioners, please brainstorm too. If you see similar kinds of things, and what I think would be most helpful for us is not to replicate the kinds of things that already got done that are specific to the particularities of a certain type of disaster, but to try to think about ways that the law should be adjusted to give government flexibility to respond to emergencies. Things like what I mentioned, sort of like removing obstacles to importing licensed professionals to support response, or adjusting the Emergency Services Act to make sure that it's make it less susceptible to judicial challenge if there are, political opponents who want to shut down an emergency response. So I can't believe I'm saying that. So anyway, with that, we will close this item and move over to the next.
Brian, before we move on,
Thank you, Alex.
wait, before Alex goes, could I note for the minutes that the commission thanks Alex for her hard work and dedication?
Absolutely.
Can I get unanimous assent on that?
Yes.
So you're graduating, right, Alex?
Next year.
Yeah, in the summer, yeah.
Okay, well then, yeah, definitely we'll clap if you're, especially we might not see you anymore.
And how weird is this? I have never met Alex in person. All the work that she's done, it's been by Zoom. So when we reopen our offices, I think I'm going to try and arrange to go over to the law school and at least like pretend to shake her hand or something.
Elbow bump or something.
But Brian, you probably never had this much eye contact with someone that you never met.
It's true.
So that's good.
All right, thank you. We'll move on to the next item.
Roll call vote?
Roll call vote, Barbara?
Yeah, do we need a roll call vote for that?
I asked for unanimous assent and I got it.
Yeah, we're gonna waive on that.
It was informational only. Yeah.
Okay. Thank you, Alex.
Thank you.
I'll see you.
All right, let's go to item number 5, which is Barbara's trial court restructuring.
Okay, well, so at the April meeting, the commission started to revisit a set of 6 code provisions relating to representation and indemnification of courts and court personnel, which the commission had set aside for further study when it was preparing a big report on trial court restructuring in 2002. And the commission decided how to handle 5 of the 6 code provisions for purposes of a tentative recommendation. But it asked the staff to do further research on the last provision, which was Government Code Section 27648. And that's the topic of today's memo, the results of the research that the staff has done. The memo is complex and long. I don't plan to repeat its content. The commissioners, I presume, to have read it, and you folks are really good about that. I do want to go over a few key points before raising questions for the commissioners to decide. The Government Claims Act was enacted in 1963 on recommendation of this commission after extensive study. And importantly, I think for present purposes, the Government Claims Act replaced what was described as a Byzantine claims system consisting of numerous both state statutes and local ordinances on the topic. And so it was intended to be a comprehensive codification of the law of governmental liability and immunity in California, and essentially to confine governmental liability to rigidly delineated circumstances. The Government Claims Act seeks to balance the competing interests in holding the government accountable for a wrongful act that causes harm to an individual, and also protecting the public treasury and facilitating basically a functional government, a government where employees feel comfortable performing their duties without always looking over their shoulder to worry about liability. The Government Claims Act addresses not only when a government entity must compensate a person for a wrongful act, but also when a government entity must represent a government officer or employee who's accused of a wrongful act, and when a government entity must reimburse a government officer or employee who pays for his or her own representation instead of having the government provide it when they're entitled to representation. And that makes sense because the costs of providing such representation are another potential drain on the public treasury, and concern about incurring those representation costs could impede public officers and employees in doing their jobs. So as you might expect of legislation that was drafted through the Commission's careful study process, the various requirements and limitations of the Government Claims Act reflect some very thoughtful policy decisions. For example, the Act permits a public entity to pay for the defense of a witness who testified on behalf of the public entity, but not if the witness's testimony was false in any material respect or otherwise not given by the witness with a good faith belief in its truth. And similarly, the Act requires a public entity to reimburse an employee who pays out of pocket for defending against a claim that arises in the scope of employment, but not if the public entity establishes that the employee acted or failed to act because of actual fraud, corruption, or actual malice. So those rules are based on a balancing of the interest in enabling government employees to do their jobs without worrying about potential liability, but also making sure that public funds aren't used to help an employee engage in reprehensible conduct. As originally enacted, the Government Claims Act does not appear to have contained any specific references to claims against courts and court personnel. A handful of provisions on that subject located elsewhere in the codes were enacted before and shortly after the Government Claims Act, including some of the ones that the Commission's been looking at. In 1977, the legislature amended the Government Claims Act's definition of employee to expressly include judicial officers. And the same bill that did that is the one that added section 27648 to the government code, which is the section that the Commission's focusing on today. The major reforms restructuring California's trial court system happened about 20 years later, around the turn of the century. And two aspects of those reforms are most pertinent here. First, the Trial Court Funding Act made the state responsible for funding trial court operations instead of the counties. And due to that switch in responsibility for funding trial court operations, it became inappropriate for counties to bear the expense of representing and indemnifying courts and court personnel. That responsibility should be transferred to the state instead of the counties. And then second, the Trial Court Employment Protection and Governance Act revamped California's personnel system for trial court employees. They became employees of the Superior Court instead of employees of the county as in the past. And again, this change means that counties should be relieved of requirements to represent and indemnify court personnel. So following the trial court restructuring reforms, the legislature, with help from the judiciary, enacted not just one, but 3 separate bills revising the Government Claims Act to account for the trial court restructuring reforms. The details are described in the memo. The key provision is section 811.9. We've discussed that one before. It applies notwithstanding any other provision of law, and it gives the Judicial Council broad authority to manage claims affecting trial courts and trial court personnel. The statutory language isn't 100% clear cut, but combined with the bill analyses, it seems fairly obvious that the intent was to broadly address pretty much any type of claim involving trial courts and their employees, also to put the Judicial Council in control because it now holds the purse strings for the judiciary after enactment of the Trial Court Funding Act. And finally, to treat claims involving the courts in a manner that's similar to how the Government Claims Act treats claims involving the state. So with that background, let's turn to Government Code Section 27648. The text is shown in the middle of page 32 of the memo. It says, it's very short, it says, if because of a declared conflict of interest, any judge who is otherwise entitled to representation pursuant to section 825, 995, or 27647 is required to retain his own counsel, such judge is entitled to recover from the appropriate public entity such reasonable attorney's fees, costs, and expenses as were necessarily incurred thereby. In other words, section 27648 provides for reimbursement of judges who normally would be entitled to legal representation pursuant to section 825, 995, or 27647, but must instead obtain and pay for other legal representation due to a conflict of interest. And that section applies only to judges, and it is not in the Government Claims Act. Now, what's critical to note here is that the Government Claims Act contains its own provision requiring a public entity to reimburse reasonable attorney's fees, costs, and expenses when there's a conflict of interest that prevents it from providing representation to someone who would otherwise be entitled to representation. And that provision of the Government Claims Act is section 996.4. It's shown on page 10 of the memo. It applies to all public employees, not just judges. It applies only when the act or omission in dispute occurred in the scope of employment. It does not apply if the public entity is able to establish that the employee acted or failed to act because of actual fraud, corruption, or actual malice. And it does not apply in a disciplinary proceeding by the public entity against the employee. So it includes some carefully thought out limitations as we were discussing with regard to the way the Government Claims Act was drafted by the Commission. And the question here boils down to, is there any reason to retain section 27648 given the existence of section 996.4 in the Government Claims Act and the three bills demonstrating the legislature's intent to make the Judicial Council broadly responsible for managing claims affecting the trial courts and trial court judges in accordance with the Government Claims Act after trial court restructuring. And the staff's tentative answer, after looking hard at the situation, is that Section 27648 appears to be obsolete and probably should be repealed. And that is a tentative answer, and we may get some comment that convinces us otherwise and for some reason. But pages 32 to 40 of the memo explain the staff's reasoning. In short, Section 27648 refers to three different kinds of representation: representation pursuant to Section 825, representation pursuant to Section 995, and representation pursuant to Section 27647. Sections 825 and 995 are in the Government Claims Act. Section 995 is the provision that actually creates a right of representation. Section 825 focuses on indemnification instead, and it just implicitly reinforces the existence of a right to representation as specified in Section 995. The requirements for being entitled to representation under Section 995 overlap with the requirements for obtaining reimbursement of attorney's fees, costs, and expenses when there is a specific conflict of interest under Section 996.4. And so what that means is that Section 27648 is essentially duplicative of Section 996.4 with regard to representation pursuant to Section 995, except that Section 27648 refers to a declared conflict of interest rather than a specific conflict of interest. And to the extent that there's any difference between a declared conflict of interest and a specific conflict of interest, I think Section 996.4, the one in the Government Claims Act, would seem to control, given the legislature's apparent intent to have the Government Claims Act override conflicting law in this area. So it appears for those reasons that there's no need to retain the parts of Section 27648 that refer to representation pursuant to Section 825 and representation pursuant to Section 995, that those parts are essentially duplicative of what's in Section 996.4. That leaves the part of Section 27648 that refers to representation a judge is entitled to pursuant to Section 27647. And at pages 35 to 39, the memo gives a lot of reasons why the staff thinks that that part of Section 27648 is not necessary anymore either. And among other things, the Section 27647 is permissive in how it's phrased. The statutory language doesn't seem to create an entitlement to representation. A case named Bloodgood, an old case, appears to be the only case that holds that reimbursement was proper under Section 27648. And it involved a narrow set of facts that are unlikely to arise in the restructured court system. A later case named Plaster limited the Bloodgood case to its facts. There seem to be few, if any, recent cases involving Sections 27647 and 27648. And, perhaps most importantly, the three bills revising the Government Claims Act to reflect trial court restructuring, as well as the court rules that implement those three bills, I think events a legislative intent to build a comprehensive system for handling claims affecting the judicial branch, just like the original legislation crafting the Government Claims Act was an intent to be a comprehensive statement of liability and immunity rules for California. And so, you know, my impression after thinking really hard about this is that the part of section 27648 referring to representation pursuant to section 27647 appears to be obsolete, just like the parts referring to representation pursuant to sections 825 and 995. And so the staff's recommendation and on this one is to propose to repeal section 27648 as shown on pages 39 to 40 of the memo. And so that's a complicated analysis, and I'm very interested to hear what any of the commissioners have to say about it.
Any comments? Yeah.
As I read through it, concurred with your conclusion. I just want to point out that the 2002 bill by Bob Hertzberg that made some amendments, I was working for Bob Hertzberg in 2002 and had no idea he was working on that. Oh. So I concurred with your conclusion.
Commissioner Carrillo?
I also like the new direction. It seemed to me like the big takeaway is that the overall intent here has been to, consistent with other developments, move discretionary control over these issues to the Judicial Council. And that seems to be the direction that the staff is taking with these latest amendments and proposed changes. So, you know, I see that that's the direction that the law is moving. Since the staff recommendations are consistent with that, I'm fine with them.
Agree. Do we need a motion to, Barbara, do you want a motion on approving the?
Yes, so it would be a motion to propose to repeal section 27648 as shown on pages 39 to 40 of the.
I so move.
I'll second it. We should take actually, we should do a roll call. All right.
Yeah. Okay, so Commissioner Carrillo?
Aye.
Commissioner Kubas?
Yes.
Commissioner King?
Yes.
Commissioner McAllister?
Aye.
Commissioner Chair Miller O'Brien?
I think I'm next. I can't hear you, so.
Oh, I'm sorry, Commissioner Rubin? And
you have to say, Commissioner Rubin, you need to say aye. Yes.
Simpson, aye.
Okay, Commissioner Simpson, aye. I think there we go. All right. Okay, so there are just a few more questions at the end of the memo. One is that we had previously discussed Government Code Section 27647, which interrelates with the provision that we just discussed. And the commission approved a amendment of that provision, but that amendment was drafted before the staff was really aware of the full breadth of the Government Claims Act, and the amendment assumes that there are both actions that would be under the Government Claims Act that would fall within section 27647, as well as ones that are outside the Government Claims Act. And having gotten more familiar with the Government Claims Act and its breadth, and particularly how it, in a very precise manner, addresses, both criminal claims and administrative adjudications and witness testimony, not just situations where someone's appearing as a defendant. My impression is that at this point, 27647 should really just give authority to the Judicial Council to be the entity that it receives the request, that makes the request for County Counsel to appear on behalf of a court or court personnel. And so a possible revised amendment is shown on page 41 of the memo. And the question is whether you want to stick with the original memo, original amendment, which is shown earlier in the memo, or whether you want to go with this revised version shown on page 41. Does anyone have thoughts on that?
Yeah.
Commissioner Carrillo?
I was going to go let Rick go first. I renew my previous comments. I'm on board with the new direction.
Second.
So is that's a motion then?
Yeah. So we need to do the roll call again.
Well, does anyone have anything they want to say before we do a roll call?
I don't, because I agree with the rationale. Judicial Council is going to be the best approach,
Agree.
aligning with how they are managing these.
Okay, so Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
and Commissioner Simpson.
Aye.
Okay, and then the memo also includes two proposed clarifications. One is of Government Code Section 811.9, just to clean up some of the language that I personally found unclear when I first started reading it. The amendment is shown on pages 42 to 43 of the memo. And does anybody have any thoughts on that one?
I thought it looked fine.
Same as before.
Okay, so we have a motion on that?
I'll make the
Yes.
motion. Yep, or I'll second.
Jane can do it.
Okay,
I second Jane's motion.
There we
all
go.
right. Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
and Commissioner Simpson.
Aye.
Okay, and then there is also a proposed clarification of Government Code Section 68111 that's shown on page 44 of the memo. Does anybody have anything to say about that one?
I do have a question on that one. It appeared to me that A and B might be kind of in conflict. That is to say, A, correct me if I'm wrong, Barbara, A is an exception to B, right? B covers judges' representation of how they're covered by public expense by the Government Claims Act. A is an exception to that. There are circumstances where a judge can have representation at his or her own expense. Yes? I mean, is that?
Well, I think, in general, anybody, anytime is entitled to representation at their own expense. I don't know that I see it as an exception to the Government Claims Act so much as, it's almost, since the provision is supposed to be at someone's own expense,
Right.
it's almost as if it doesn't need to be said, but
Well, that's kind of what I was going to ask. Is that something that basically is A intended for circumstances when they're not entitled under the law to representation at public expense, but there's nothing that precludes them from getting their own representation? Or is this simply to say, if they want to get representation and they want to pay for it themselves, even though they could get reimbursed, they can do that too? I mean, it wasn't clear to me what kind of circumstances that was intending for. The law was talking about, in contrast to what we've been talking about earlier and the rest of this memo about the public expense for this kind of representation. So
well, I tend to agree with you that it's kind of, it's not altogether clear to me why one would need a provision in the law that says you're entitled to, a judge is entitled to their own representation at their own expense. But that is how the provision was interpreted in this Attorney General opinion that I referred to in the proposed comment there. You know, I guess I have some reluctance to propose to repeal it altogether because I think there just might be some concern generated by that might not, you know, that people might like to leave it in the law, but benefit from the clarification that's provided in the proposed amendment.
I think the question is the answer. The fact that you're asking the question tells you that there could be some confusion. I can just tell you that when you are dealing with matters like immunity and or dealing with just insurance, basically protecting and trying to repay expenses incurred based on claims asserted. So for example, if someone gets upset with, you know, Commissioner Simpson because they think that he's a slouch during these meetings, and then we say we have county counsel, and you say, I don't like that person, I actually know him, and I would prefer for my cousin Lou to represent me. We might not, or county counsel or the state may not reimburse you for your own decision to have your own representation. And so for those purposes, then hopefully the statute would help to address that to some extent. So I think that we should not repeal it and that we should leave it in because it helps to head off any concerns or confusion or questions. That's what I'm just offering.
Yeah, I don't disagree with that. It's a little odd, but
it isn't, because it comes up, and especially within a hashtag Me Too and with Black Lives Matters. We have right now, everything is so hot. People are even blaming people for catching COVID in court. So this stuff is actually, I used a really kind of innocuous example, but this is probably one of the most helpful statutes that we are looking at in terms of restructuring that could possibly come up, especially in the next year, assuming that we're back to normal.
Okay, I concur with. I mean, it's if there wasn't in the law, is there anything that prevents a judge from getting his or her own counsel at their own expense? Probably not.
No, it could be.
But since it's in the law, taking it out would leave a conclusion that you're trying to remove that option. Then I get that. Then my question is, what does B add? It kind of read to me, it almost like a comment. That is, what does B add to the presumptive authority of judges to get their own counsel? you're simply saying, oh, by the way, representation of public expenses is covered by the Government Claims Act. So it
As
wasn't clear
opposed
to me.
to another, it could have been covered by something, an additional type of coverage. It could be covered by a union. A lot of the courts are unionized. It could be covered by different things. So that this statute is directing people right back to the Government Claims Act. So to address that question of who will pay for my additional counsel to represent me in the sexual harassment suit or whatever else, which could be excluded.
Okay. Well,
Barbara, go ahead.
I think, Rick's comment about possibly putting that language in the comment instead of in the statute, that would probably work fine. So, it may be that it is more appropriate to put that in the comment.
I don't think so. Because you need to have a statutory authority to help you address or to deny coverage. How could you do that if it's in a comment? And not every practitioner looks at comments. Comments are helpful when you're having questions about what was intended.
maybe that's part of my confusion. That B to me simply looks like it's saying, oh, by the way, there's this other body of law for representation of public expense.
I
So,
think it's clarifying a question that comes up a lot.
okay, I mean, I don't think it's harmful. It wasn't clear to me what it was adding to. It was simply pointing to the body of law. Anyway. I guess we scared Barbara off.
Oh. All right, Brian, and then Brian, are you here? And then Steve's not here either. All right, well, then.
I'm here.
Oh, what do you want to do? Because Barbara's not here and she wanted to take a vote on this.
Oh, where'd Barbara go?
I don't know. I think we scared
her
her off.
Wi-Fi was unstable, I could tell. Split you. Did we want to call a vote and then tell her, or do we want to?
No, why don't you hold off? I assume this is just a temporary technical problem.
Yeah.
And I would rather her lead this than me. She knows it much better than I do, and it's technical. So
can we take a break?
Oh yeah, I was going to say, why don't we take a break? It's 11. You guys have been working.
Sure.
Let's take a break. 15 minutes or 10? What do you want?
Up to you all. There she is.
Okay.
Barbara's back.
I'm sorry, my battery went dead and I had to move. So I missed a little bit there.
Everyone said, "Where's Barbara?"
Yeah.
Okay. Do we have a motion or do we have more discussion?
Yeah, we moved to take a break.
Okay.
But I mean, before we go, did you guys want to do a vote? Because I just think we just leave it as you proposed, and
It's fine.
Let's finish up.
It's a tentative recommendation, so
I like it.
we can send this out for comment and we'll see what people have to say about it if that's okay. So is there a motion then to revise Government Code Section 68111 as shown in the memo?
I move approval.
I'll
Second.
second it.
Okay,
I think
Commissioner,
Crystal was first.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
and Commissioner Simpson.
Aye.
All righty. I think that completes this memo. Thank you all.
You know what, before we go on a break, I just wanted to tell Brian, I think that we missed for the next memo, House Statute 1985 A through F works or fits in with this. I don't see any exclusions for consumer notice And I don't think it was considered. So I just, maybe we take some time, maybe you might want to look at that statute just to see if maybe you guys
What
did.
code are you talking about? CCP?
CCP for consumer notice, which would address one of the first questions that you had.
Okay.
Okay, bye guys, see you in 10. So I have 57